We now go to Furst versus DeFrances. And counsel, you are recognized.
Thank you, Your Honor. May it please the court, Jason Lessinger on behalf of Sarasota County Property Appraiser Bill Furst. In the case on appeal, the second district has determined that property is only subject to back assessment when specifically identifiable property or an improvement is skipped entirely. This ruling creates an inequitable result, not only in the case at bar, but will also do so in the future, because it will allow certain taxpayers to avoid back taxes if a clerical error does not result in specifically identifiable property being excluded, while other taxpayers who may suffer a clerical error that does would be subject to back assessment. Prior decisions have focused on errors in judgment versus clerical errors to determine when back assessments are allowed. The second district has essentially created a new category of property that is mistakenly undervalued and not subject to back assessment. The problem is errors in judgment and clerical errors both result in property that is mistakenly undervalued. The second district's opinion ignores the previous distinction between errors in judgment and clerical errors and focuses only on the words escape taxation and requires it to include specifically identifiable property, but that is not in the operative statute. The second district reaches this result.
Counsel, let me ask you this. Is there anything in this particular statute, the text of this statute, that supports this distinction between clerical errors and errors based on an exercise of judgment?
Nothing in the operative statute 193.092 addresses that. You have to look at 197.122 to get to clerical errors or errors of omission or commission.
But isn't that other statute talking about something different? I mean, that statute doesn't apply here. Isn't that correct?
It applies to the extent it is the statute that is used to correct the error that took place in this case. So that was an issue at the trial court. The statute
that doesn't apply to back taxes.
Does not apply to back taxes. The statute that we're dealing with addresses back taxes that should have been assessed when they were not. Excuse me, taxes.
And I think in the way you've briefed and argued this, it's very clear that as far as your authority for issuing these back taxes, you're relying only on 193.092.
That is correct, Your Honor.
Okay. Thanks.
Now that statute is mandatory in nature, and if the statute said, if any specifically identifiable property escapes taxation, you can back assess. If that's what the statute said, it would cover the situation. But the statute doesn't say that. The statute says, when it will appear that any tax should have been collected against any property, the property appraiser shall make the assessment. Those are the critical words in the statute.
Was the assessment here not lawfully made?
No, the assessment was lawfully made under 197.122.
No, what I'm saying, the original assessment, the one that was wrong, was it lawfully made? If you focus on the first clause in the statute here, when it shall appear that any ad valorem tax might have been lawfully assessed, but that it wasn't lawfully assessed, ... Is that condition satisfied here?
It is satisfying because the taxes that escaped could have been lawfully assessed, but for the clerical error.
Well, but that would also be true for a judgment error, right? I can go, but I mean, in terms of the words of the statute, if I go back and I say I could have lawfully exercised my judgment in X, Y, or Z way, therefore here's an extra bill. I mean, isn't that the implication of your argument? I mean, you're essentially equating the word lawfully with the word correctly.
I'm not equating the word lawfully with correctly. A error in judgment where a property appraiser then tries to go and back assess for that error in judgment is not a lawful assessment. So when you have an error in judgment, the property appraiser is not allowed to go back and correct it because it would not be a lawful assessment. It is a lawful assessment when there is a clerical error that results in value escaping taxation. Then 197.122 allows it to be corrected, states that those taxes are valid ab initio, and then you go to 193.092 to look and say, well, here is some ad valorem tax that should have been collected. It wasn't because of a mistake, and the property appraiser shall then make the assessment. And then there's a discussion about how they do that and when the property escapes taxation. But the focus on the statute is when tax that should have been assessed was not assessed, it can then be assessed.
Counsel, if the piece of property was just omitted inadvertently by the property appraiser's office, the whole property, would there be a lawful assessment of that property?
If the property was entirely omitted from the roll, there was not a lawful assessment of that property because it wasn't assessed.
So isn't your argument essentially the same here, where there was a computer programming error and the property appraiser's office, because of the programming error, did not make a proper assessment? Isn't really your argument that there was not a lawful assessment because of the computer conversion error made so that the statute is applicable?
An incorrect assessment made, whether it was lawful or unlawful at the time the mistake was made, I don't really view that as the issue.
Well, let me, that makes sense to me, and let me just dig down. It says lawfully assessed or collected, and it's no question that the lower amount was lawfully collected, but I don't see how you could say it was lawfully assessed in light of Article 7 of the Constitution, which commands a just valuation, which is a fair market value. So if you assess it something that's not just value, that's not an assessment, and it would seem in accordance with the Constitution. So I would view that as wouldn't you view that as a unlawful assessment or not meeting the lawful assessment requirement?
Again, it's an incorrect assessment, which is unlawful under the Constitution, which is why it should be corrected. So it could have been lawfully assessed. And again, prior question, if it is an error in judgment that would then result in a back assessment, that is not a lawful assessment.
No, but counsel, I mean, it sounds like, but the path, I mean, I understand what the questions that my colleagues have just asked you, but they've led you down a path that shows that there's really no difference between these clerical errors and errors in judgment, because if you, then you could always say the Constitution requires a fair market valuation. I got it wrong. The actual fair market valuation is X, and here's your extra bill.
The purpose of this statute, as stated in Borash v. Mills, is to ensure that the tax roll speaks the truth. When there is a clerical error that results in an assessment that is inaccurate and does not meet the constitutional mandate, this statute and 197.122 allows the property appraiser to fix it so that just value is reflected. Now, the second district has used the Korash opinion to reach the result that they've reached, but they have done so by focusing on the facts of that case, and they've effectively ignored the broader legal concepts that the Korash court was trying to enforce. That is the basic principle of taxation, that everyone pays their fair share. Ms. DeFrances is not paying her fair share, and I don't know why the second district elected to fashion a remedy for her, because she's simply the beneficiary of a computer glitch that gave her a tax break that she was not entitled to.
Your argument about fair share means that any error is correctable. I mean, it seems to me it's a broad purpose argument that really has no limitation based on exercise of judgment versus clerical error. I mean, again, I'm just these arguments, they don't really fit together very well. And tell me why I'm missing the cohesiveness of your argument.
I think the Korash court addresses it squarely. There is a need for the tax roll to be complete. There is a need for those figures to be final. And when the property appraiser exercises their judgment and makes a judgment determination, reasonable people can differ as to what that judgment is. The property appraiser does not then get to go back and fix their error in judgment, because that would be inherently unfair. However, when the property appraiser correctly exercises their judgment, and then that judgment is not carried onto the roll due to a clerical error, that is exactly what this statute is intended to fix.
But Korash, ultimately, they had the principles that you're talking about, I mean, they had principles cutting in both directions, but at the end of the day, they tied the reasoning of their decision back to the words of the statute, in the sense that the property appraiser in that case decided to independently assess the improved part and the land, and the improved part, quote unquote, escape taxation completely. And the court grounded that distinction in the words of the statute.
Right, because again, the court was trying to enforce the broader principle of law, and the very unique facts of the Korash opinion required them to say, look, you knew the hotel was there, you knew there was a tax liability, and we're not going to let you create this cute argument about real property and say, well, hold on a minute, you assessed the land, the improvement was on the land, there cannot be a separate assessment. So in enforcing the broader principle of law, they addressed the facts of that case. The problem is that Ms. DeFrances is now doing the same thing. She has come into court and said, look, under Korash v. Mills, the facts of that case address specifically identified, in that case, a specifically identifiable improvement. So Ms. DeFrances is saying, oh, well, since you can't do that in my case, I get to raise the same hyper-technical argument and say, well, you can't really tell which lot was skipped, so you can't specifically identify it, you can't back assess. But it ignores the broader concept. And it ignores the fact that she is essentially in the same position as the hotel owner in Korash. She knew she had 5 waterfront lots. She knew they were valued at millions of dollars, and she got a tax bill for $302,000.
Could you articulate for us, I mean, what would the principle be if the logic of your position is basically that, the law requires the assessment to be done right, and therefore an assessment that's not done right is unlawful and can be fixed? I mean, how would we articulate the principle both that would tell the property appraisers what they have to do, because this is a mandatory statute, but that would also give some certainty to the taxpayer so that they wouldn't be subject for the next 3 years to essentially the tax appraiser saying, sorry, we realize now that we could have lawfully assessed more and here's your extra bill. I mean, how would we, it doesn't seem like the clerical versus judgment line. I mean, A, that's not statutory, and B, it doesn't seem like a principled distinction. I mean, what should the rule be according to you?
It should be that when value escapes taxation due to a clerical error or an error of omission or commission, then a back assessment is proper. When the property appraiser exercises their judgment and makes a judgment determination, that cannot go back and be fixed. And the line should remain based on the type of error. Is it a clerical error? Did the property appraiser correctly exercise their judgment? And then the reason that correctly exercised judgment does not end up on the roll is due to a key punch error or a clerical error, or in this case, a computer system transfer data error. Under those circumstances, the taxpayer is getting a windfall if they are not back assessed. And that is where the line should be drawn.
Counsel, let me ask you about the language in the statute regarding escaping taxation. Now, I realize that's not the only language in the statute. We've got to look at the whole context of the statute and consider that language in the context of the first sentence that makes reference to lawfully assessed or collected, so on. But tell me why, when we look at the words escape taxation, it does not bring to mind a total failure to have taxation imposed. Escape suggests a total failure to be subjected to tax. And to have what you are suggesting to interpret the statute, again, this distinction between clerical and exercise judgment, there's nothing in the text of this section of the statute that supports that. And I'm just trying, it seems like that what you're arguing, there would just be so many better ways that the legislature could express that than the particular language that they have chosen in this section, particularly the parts of it that refer to escape taxation. And I don't think we can read the first sentence without considering that subsequent language, as we're trying to understand what they're talking about when they talk about a property that might have been lawfully assessed or collected, taxes that might have been lawfully assessed or collected.
Not sure I followed your question, Your Honor.
Well, forget that. We'll move on. If you didn't follow, you're in your rebuttal time. You can save it for rebuttal.
I'll reserve, Your Honor. Thank you.
All right, counsel.
All right, may it please the court, my name is Sherry Johnson from Ms. DeFrances. The Second District Court correctly held in this case that back assessments are only authorized for property that is omitted from the tax roll, not just property that's simply undervalued. This was consistent with the plain language of the statute, which is phrased such that it only allows back assessments for property that escapes taxation. It's also consistent with the Department of Revenue regulations that implement this statute. The Department of Revenue regulations give instructions to the property appraiser for how to implement it, and they specifically provide for the property appraiser to make a separate assessment for each year that the property has been entirely omitted from the tax roll. There is no other provision for property that's undervalued or partially omitted. It's just for property that's entirely omitted from the tax roll. The property appraiser in this case wants to expand the back assessment statute to include property that is mistakenly undervalued in a prior tax year, but that is a matter for the legislature because the statute as it's written is clear. And the statute is written to strike a balance.
Counsel, if it applied only to property that had not been assessed at all, wouldn't the statute should have said it may have escaped assessment? But it doesn't. It says escape taxation. So it seems more broadly than you suggest. Here we have a situation where because of computer error, property was assessed, but clearly not taxed as it should have been because of the computer error. So doesn't the statute support your opponent's claim?
I don't think so. The property did not escape, well, it didn't escape taxation under the statute because it was taxed. It was taxed, the taxes were paid. The entire property was assessed and taxed. So no, I don't believe that language makes a distinction.
So if there were a computer error, and in this case, instead of assessing what should have been 1,000 acres, there was a computer error, and instead of 1,000, it showed 10. So that there was an assessment, but there was tax, albeit way too low. Should that be then excluded from this statute under your arguments?
Correct. That would not be subject to back assessment. And to be clear, because I know we've talked a little bit about the fairness and equity issues here, the legislature has had the opportunity to consider those issues, and I would suggest that they did actually consider them to some extent. So,
but in my hypothetical, why in my example wouldn't there have been 990 acres escaped taxation under the statute and also included under back taxes?
Sure. I'm assuming in your hypothetical that the property is under one tax ID, it's one parcel, and that it was just an error in the size, which is what the situation was in this case. Obviously, if you have multiple parcels of property and you have a parcel that's not assessed, sure, that would escape taxation, that would be subject to back tax. But if you have a situation like the instant case, where the instant case, there was one parcel and the errors were made in the size, the waterfront location, and the extent to which it was homestead property, that parcel was assessed. It was just, there were some mistakes made.
But wouldn't there be an escape of taxation? Am I hypothetical?
No, I don't believe so, because the property was taxed. It was just taxed at an erroneous amount because of clerical error. And again, the legislature, I think the legislature is okay with that. As I was getting to, you look at subsection.
Let me just interrupt. You keep and ask. You keep saying that it was taxed. The Constitution requires an assessment at fair value. Was it assessed at fair value? I mean, at just value?
No, it was not because of the clerical error. But
So
that
it
happens
was,
all the time
assessed
both
in
ways.
contravention to the directives of the Constitution. Why is that a lawful assessment?
The determination of whether the just value, whether it was assessed at just value, I think is made at the time of the assessment. At the time of the assessment, it was lawful. The fact that ultimately later a mistake is determined to have been made, I don't think changes that fact. Just like with a taxpayer, if a taxpayer determines a year later that there was a mistake in the tax roll.
But you said that, but I mean, how is it a lawful assessment if it's not an assessment at just value when the Constitution requires that all property be assessed at just value?
Well, I believe that it's a lawful assessment in that it's collectible. The property appraiser followed the procedures and collected.
Well, I mean, but it says lawfully assessed or collected. I would agree with you that whatever was collected was lawfully collected, but I don't see how you could say that it was assessed consistent with the law of Florida.
I think, well, when we talk about a lawful assessment under this statute, which again is under...
It's not a defined term, but so...
Right, but I read the term lawful assessment here as being one that was...
Any assessment.
One that was properly, how should I say it, followed all the procedures for a proper collection of tax, I guess. I see it more as a procedural issue, is the way I would interpret it. And again,
also the logic, again, if you look at it that way, which I think is one way of looking at it, then essentially you've got a 3-year period during which any do-over that is arguably, more consistent with what just valuation is on the table, which would be, very inconsistent with how this statute has been viewed by the court before. I'm not saying that that's subjectively not a possible way of looking at it, but I mean, that would be a pretty stark departure from what we've done before.
Right, correct. As just pointed out, I mean, if you were to interpret this as meaning that any assessment that was not at just value could be subject to a back assessment, that is completely inconsistent with the way this court has interpreted.
Well, I mean, I also don't understand why you would have to reach that conclusion, because there's obviously some discretion in determining what fair market value is. There's a range. And so as long as there wasn't an abuse of discretion, Mr. Lessinger said any exercise of judgment, but I would say as long as it was within the range of reason, so that you couldn't say clearly, which you can here, that this is not a just valuation, that you would say it's lawful. I mean, the property appraiser exercised the discretion and determined that it was a just valuation. It wasn't an abuse of discretion. It's within the range of what just value is. So that would be a lawful assessment, as opposed to one that you can look at and say, no reasonable person could say that this was a just value assessment, so it's not lawful. I mean, I don't know why it would open up the door to look at everything again.
One thing I want to point out, I'm going to try to get to is subsection 3. I like you to take a look at the subsection 3 of the statute, because I think that will give you more of an indication as to the legislature's intent and thinking and looking at the statute. In 2010, after Korash, after these cases, had all happened, the legislature amended the statute and adds subsection 3. And basically what it does is prevents the property appraiser from back assessing an omitted building or improvement if the owner complied with all necessary permitting requirements. Under this amendment, even the motel in Korash wouldn't be subject to back assessment. The legislature, to me, by doing that, they have determined that even if an entire improvement is omitted due to clerical error, it cannot be back taxed, regardless of whether there's a windfall or as an error in the just value of the property, because this statute is intended to protect the taxpayers from that kind of surprise assessment, or not surprise assessment, but new assessment. So I think that the notion of the property appraiser, receiving a windfall due to a mistake by the property appraiser, that was not a concern by the legislature. And I think by putting those protections in here for property that was completely omitted from the tax roll, sends a message that their intention here is to protect taxpayers as well as to ensure a fair tax roll. And again, the errors in this case were not of the type under the plain language of the statute, which requires escape taxation. This is not a situation where there were multiple parcels and several were left off the tax roll. This is one where there was a parcel that was assessed, there were mistakes that were made, but the taxes were assessed against this entire parcel. The Korash court distinguished between taxes that increase the amount only and back taxes that add an improvement that was accidentally omitted. I believe the second district, they were correct in following Korash in that this statute is not meant to allow the property appraiser to correct errors in amount. It's just to allow property appraisers to correct errors in property that is left off the property. And that's the only case where this court has ever really considered this issue. And I think it's important that this court follow that precedent. The court in Korash also specifically iterated that a back assessment is proper under the statute only if there's no judgment being exercised, which I think we've all agreed on, and the property is not therefore included or is just late in being enrolled and billed. So whether you look at the Department of Revenue regulations, which interpret this statute as only applying when property is completely omitted from the tax roll, or you look at the only prior Supreme Court decision on these back assessments, both of them have distinguished between increases in amounts and changes that add property to the tax roll. So in conclusion, I think the legislature could provide for back assessments for property that has been undervalued, but they've chosen not to do so. They could provide for back assessments for any year in which a clerical error was made, but they have not done so. And in fact, as I pointed out, in 2010, they actually made it more difficult to back tax property that has been omitted from the tax roll, even an entire building.
Just to be clear, you're not claiming that your property can't be back assessed because of the 2010 statute?
No.
Okay.
No, that's not by. I'm just showing that as legislative intent that they considered the fairness issue, and apparently the legislature is okay with an entire building being omitted, as long as the taxpayer had done all the permits properly and everything. This statute on its face only provides for back assessments for 3 years, only for property that has escaped taxation. Again, in the instant case, this property was assessed. It was assessed, it was taxed. It was just undervalued due to errors in the size, location, and the homestead characteristics of the property. I believe the second DCA correctly held that in these circumstances, no property had escaped taxation, and their opinion is consistent with the statute, Department of Revenue's regulations, and this court's decision in Korash. So I would ask that you affirm the second DCA's opinion in its entirety.
Thank you, counsel. We'll now hear a rebuttal argument.
Thank you, Your Honor. Ms. Johnson has directed you to Section 3 of that statute. I would direct you to Section 2, which confirms the expansive nature of that statute because it applies to property of every class and kind. Now, the word class has a distinct definition, but kind suggests an expansive statute. And I would again go back to Korash v. Mills, because the property owner in Korash v. Mills was basically saying, look, I had one piece of property. It was real property. It consists of land and improvement, and you valued it. You don't get to come back and say, I'm going to revalue your real property by adding the improvement that was there that you missed. And the court said, no, we're not going to let you get away with that because the escape was so clear and ascertainable, they missed the improvement. So now Mr. Francis is coming in and saying, well, there was nothing skipped here, so you should just follow Korash. But the same principle applies. The only difference is we don't know which lots were skipped, but her escape is just as clear and just as ascertainable. For a property that was valued in excess of $2 million was valued at $300,000. And I'll give you another example. If the hotel owner in Korash, if the property appraiser had the two separate cards and valued them, and the one card was not lost, and the value was then entered instead of at $667,000, it was entered at $667. It was a key punch error. Well, under that circumstance, under the DeFrances opinion, there would be no back assessment because there was no specific property that escaped. The fact of the matter is that the hotel was drastically undervalued due to a clerical error, and there should be no distinction there. In both situations, the taxpayer avoids taxes that they should pay based on the nature of the error. And this distinction about, well, does it have to be a specifically identifiable property? It defeats the purpose of the statute.
So, counsel, given that this is a mandatory statute, and if you think that the sort of the baseline is that it has to be gotten right, lawful means just value, then how would appraisers comply with the stat? Would they feel like they had a sort of continuing obligation for 3 years to sort of revisit every assessment to make sure that it could be characterized as just value? I mean, because this isn't just a question of authority to change. I mean, this is a duty that you have to do this.
Absolutely not, Your Honor. The statute only comes into play when there is an error of omission or commission, or under 193.155, when there is a material mistake of fact. Those are the only circumstances where the property appraiser can go back and lawfully assess because there was a clerical error, because just value was not obtained, because there was a material mistake of fact. When it is an error in judgment, when it is an error in judgment, you cannot go back and reassess. So there would be no circumstance where a property appraiser could lawfully say, you know what, I got it wrong for the last 3 years. It was purely an error in judgment. Under this statute, I get to go back and fix it. That was exactly what happened. I think it's Markham v. Friedland. And the court said, no, you can't do that. So this statute only comes into play when there is a material mistake of fact, or there is a clerical error, or under the actual language of the statute, an error of omission or commission. That is not an error in judgment. And again, I've already kind of spoken to why errors in judgment should be treated differently and why there is a necessity that the tax roll be final at a certain date. And the only reason you can go back and fix that is, again, when there's a clerical error that causes that judgment determination to be inaccurately reflected.
I don't understand how the term error of commission is inconsistent with being an error of judgment.
An error.
I mean, actually, an error of, I don't follow that.
An error of omission would be omitting a property entirely. An error.
I thought about an error of commission.
An error of commission would be when a key punch when the property appraiser determines the value is $667,000 in his judgment, and then the key punch operator who's entering that into the system, instead of punching in 667,000, punches in 200,000. That is an error of commission.
Why couldn't that also have reference to an error of judgment?
Because it shouldn't under the law.
Okay, I got it. That's very clear.
And I believe I'm into my overtime here, so I would again thank the court for your time, and I would request that you reverse the decision of the Second District Court of Appeal because it creates inequitable results between taxpayers and allows some to escape taxes that are lawfully owed and others who cannot. And it's unfair. Thank you.
All right. We thank you both for your arguments, and the court will now stand in recess for about 10 minutes before we move to the next case on today's docket.